Today, I'll be discussing on the adequacy of the sexual harassment law in dealing with sexual harassment cases at workplace in Malaysia. Sexual harassment is a type of discrimination relating to sex. Sexual harassment in the workplace refers to a verbal or physical performance with a sexual nature. The Ministry of Women, Family and Community Development published statistics on the number of sexual harassment cases reported in Malaysia. The report shows the perpetual rise from the year 2013 to the year 2016. Most victims of sexual harassment do not narrate their cases because of the vague and absence of policies to deal with sexual harassment cases in their companies. According to Speak Up, sexual harassment and violence against women getting worse throughout the coronavirus pandemic in the year 2020. Although the government has delivered information to employers regarding sexual harassment since the year 1999, many companies still do not have any parameters or instruction in dealing with sexual harassment. Thus, it is the right moment where the government and corporation should start to realize that sexual harassment is a human rights issue. Constructing a safer place for praise of sexual harassment is the responsibility of the government and all employers. In this research, we are going to highlight whether the Malaysian government has introduced adequate legislations to combat and put an end to the plague of sexual harassment in the workplace. We will also be sketching out the scope of sexual harassment and the existing law connecting to it. Thank you.
Now I'm going to present the problem statement. According to the surveys carried out by organizations, the results have shown that most of the women have experienced sexual harassment in workplace. However, the results shown cannot reflect the real number of cases as there are a lot of victims not willing to make a report due to the flaws that exist in our provisions. Therefore, it is a serious issue. In Malaysia, there are several provisions to tackle this issue, but only the Employment Act 1955 is suitable and has legal force. This act grants the employer the power to investigate the complaint lodged by the victim. However, this act has its weaknesses. As it did not state the details on the procedure, different employers can have different procedures to investigate the complaints. The employer also has the right to not investigate the complaints on the ground that the complaint is frivolous, facetious, or not made in good faith. As for the Code of Practice on the Prevention and Eradication of Sexual Harassment in the Workplace, it is just a guideline which does not have legal force and not mandatory for the employer to implement an internal mechanism to address this issue. As a result, it lacks ability for the employers within the country to tackle the issue concerning sexual harassment in the workplace. Therefore, there is a need to carry out research to discuss the weaknesses in current legislation and to implement new law to address this issue. Our research questions are: what are the weaknesses in law of Malaysia in tackling sexual harassment, and what improvements can be made to overcome the weaknesses? As for our research objectives, we are to investigate the weaknesses in law of Malaysia in tackling sexual harassment and to determine the improvements that can be made to overcome the weaknesses.
My name is Nordin Dipti Roslan with the matrix number 276738. We'll be presenting regarding the significance of our research. Without further ado, among the ways our research may contribute to society is by enhancing the readers or the public's knowledge of the behaviors amounting to sexual harassment. By reading our research, they will recognize or familiarize themselves with the laws and provisions governing this issue. Following that, the readers will know the steps that needs to be taken in order to take actions against the sexual predator if they or anyone they know ever happen to be under a circumstance where they are sexually harassed. Secondly, our research can spread awareness on the numbers of victims suffered from sexual harassment at their workplace and how the reporting system at their workplace has failed them. We hoped by voicing this problem, the authorities may take appropriate measure to improve and to avoid this from keep on happening again in the future. In addition, we conducted this research as a channel to urge the Parliament to pass bills and enact laws that comes with heavier sanctions towards the sexual perpetrators. Furthermore, it is crucial for the Parliament to enact laws that are not ambiguous or vague. Moving on, three parties that we anticipated to benefit from our research are the researchers themselves, the readers, and the lawmakers. First of all, the researchers may benefit educationally by learning about issues and methods of conducting legal research, as well as professionally by improving their professional communication skills and gaining unique skills for their careers. As for the readers, their awareness or knowledge regarding sexual harassment issues may be enhanced, aforementioned earlier. Apart from the researchers and the readers, a research may aid the lawmakers and lawyers in ruling the relevant concerns pertaining to the fundamental search for the case that can be utilized as a consulting case and paves the way to the leading case governing workplace sexual harassment issues.
Hi, my name is Sadira and I'll be presenting about methodology. So what is methodology? Methodology is the techniques and tools that researcher might utilize during his or her conduct of research. So the purpose of doing it is to gather data, gauge the validity of data attained, and manifest the correlation between the information gathered and unknown facts. It is also an approach to resolve research questions in a comprehensive and systematic way. So how is it conducted? It is by analyzing and justify the data based on what has been collected. The main goal of this research is basically to provide a recommendation to prevent sexual harassment in the workplace. Next, what is the research method we used in this study? We chose evidence-based research. This is because this method matched the goals of this research, considering that the researcher will carry out doctoral research on library-based and analysis of statutory provisions, scholarly writings, guidelines, textbooks, government records, and reports. Besides, we also use mixed methods research, which combine qualitative and quantitative methods such as statutory materials, case report, and reference book. By conducting this research, it not only helps the researcher to get a better understanding, it also assists them in summarizing the legal principle and engross in scope of law under research. Next is data collection. In this research, we use both primary and secondary data. Primary data is collected by researchers directly from main sources such as Constitution and legislation. For example, the legislative acts such as Employment Act and Penal Code will be the example of sources of primary data. Let's go through primary data, in which we will distribute questionnaire and we will be conducting interviews by using this method. Questionnaires will be spread out to 40 respondents who are female workers. The data collected will reveal the frequency of sexual harassment cases at workplace and the relationship between the perpetrator and the victim. We believe as the data questionnaire guarantees the anonymity of the respondent, the primary data collected will be more accurate. For the interviews, in-depth interviews will be carried out by interviewing the female workers. It is a far more personal form of research compared to other methods. The researcher will be using semi-structured interviews by asking open-ended questions. This type of interview is flexible as the respondents are not restricted by standardized closed-ended questions, as the respondents are free to express their opinions. Secondary data. Secondary data is the data that has already been collected through primary sources and made readily available for researchers to use for their own research. Secondary data normally consists of the description or commentary on the subject matter. For instance, provided by the scholars, the researchers can further understand the topic of research and find out an inadequacy of the current legislation and the way to improve it. For data analysis, the researchers are going to use descriptive analysis method. The benefit of choosing this method is, firstly, it helps the researchers to prescribe, manifest, or sum up the information in a beneficial way, which lead to the fulfillment of the specific benchmark. And secondly, it is suitable for researchers to use both quantitative and qualitative methods in their finding in order to render a bigger picture of the issue or occurrence. And lastly, it is also that the researchers take into consideration the problem arising during the past run and how it might affect the future performance.
My name is Liu Kaijie, matrix number 271967, and I would like to discuss about the scope of studies of our research. Scope of studies refers to the extent to which the research area of this study regarding sexual harassment in workplace will be explored. It also specifies the parameters within which the study will be operating. The main purpose for this study is to study and understand the sexual harassment problem that is ongoing in the society of our country. We will also study about the existing law and penal code in our country, which protect us from sexual harassment in the workplace. Since the study is about sexual harassment at the workplace, the target population of our study will be working adults. The time period which the study will be conducted on is from the year 2000 to 2021. This study will be conducted nationwide in Malaysia. The existing laws related to sexual harassment at the workplace were Penal Code Section 354, Section 355, Section 377D, and Section 509. The Employment Act 1955, the Industrial Relations Act 1967, the Communications and Multimedia Act 1998 also provide protection against sexual harassment at the workplace.
Hello, my name is Nitesh, my reference number is 278441. Today I'm going to talk about literature review. This is more or less of sexual harassment. Sexual harassment is still experiencing from year to year. 50% of females have been experiencing such issues at the workplace. So the aim here is to highlight the importance of having specific law for sexual harassment. So as we need national sexual harassment in Malaysia itself. So there are weaknesses to be found in these kind of statutes, more Section 354, Section 355, Section 375 and Section 509. they do not offer any kind of protection to the victims at workplace involving into sexual harassment. So the Employment Act of 1995 part harassment accusation of reports have obtained, yet they still didn't have procedures of pertaining into sexual harassment. Whereas the code of practice, the higher management and employees tend to impose a limit on how the employees can voice out pertaining to this kind of issue. So as you can see, whereas the both section 2331 1A and section 233 Clause 1B of the Communication and Multimedia Act 1998, they do not define precisely on what kind of appropriate network facilities and what kind of situation can be punished throughout this kind of act. So for the implementation, in order to build a safer surrounding shielded from sexual harassment place, the government should take a quick action in tabling the sexual harassment bill. So this can compromise the defense system and procedures, consultation, and any kind of information to the tribunal. This is to ensure that the employees settle their reports wisely and properly and to avoid any cases of sexual harassment. Last but not least, the government has yet to sanction the International Labour Organization Violence and Harassment Convention to render a body in expanding the anti-harassment law, which could assist the parliament. So this could help them to even avoid sexual harassment case at workplace. Thank you.
By conducting this research, we realized that the effective prevention of workplace sexual harassment is above all a humanitarian issue. It is so important that company, legal, academic professionals recognize the emerging role of scientific research as an instrument to defeat workplace sexual harassment. Although our study merely scratches the surface of this issue, it represents one step toward that noble end.